new Supreme Court has just opened, and it's really seen as a symbol of our commitment to the rule of law, long awaited. At the same time, there are two things that have happened recently that really cause me to question whether we do have a true commitment to the rule of law and the independent administration of justice. The first is the euphemistically named Refocusing on Priority Cases, a paper that was issued by the MOJ and the NSC, which looks like the death knell for judicial reviews and any claims against the state at a time when we want the state to be accountable. And the second is a review that was announced yesterday, which seems to suggest that we're looking at actually moving away from the independent administration of access to justice. How can these initiatives be reconciled with our commitment to the rule of law?
June.
I think it's very questionable that it can be, and you heard what I said earlier this evening about my concern about refocusing on priority cases, and I gave you the example of the mother whose child was removed whilst she was seeking political asylum. Lord Bark, I'd like to ask you, what's your answer for that, having regard to that paper? Because it does seem to me that that's a very real issue that could arise from that.
I'm sure that, Carolyn, your answer will be that it can still be independent and deliver the rule of law, yes?
Yes, I mean, I don't want to prejudge what's going to come out of the review, but I mean, this was if you go back to the Access to Justice Act 1999, it refers to the separation of the funds, and I think everyone has highlighted the changing needs of society and individuals, and we've got to keep that under review, how best to respond to client needs and how to go forwards with a sustainable and high-quality service. So I don't think they're irreconcilable. I think all public services are challenged by competing priorities.
Henry, in a sense, it's a state of the legal nation question, and
yes.
What's your sense?
Well, I believe very strongly that we do need to have focus on some of the more difficult cases, on some of the less popular cases, some of the more traumatic cases, which may not play very well in the Mail or the other tabloids, and that's why I was very concerned about the paper Refocusing on Priority Cases, because it can mean one thing and one thing only, in my judgment, and that is it's going to reduce scope, I'm afraid. And I certainly feel that the only other point I'll make is I think it's essential that we have an independent body administering legal aid. I think that if it's taken over by the MOJ, that would be a complete disaster. After all, legal aid worked quite well when the Law Society were administering the legal aid budget. And incidentally, in those days, I think that it cost it cost under 1% of the budget to administer. It's now costing around about 5% of the budget to administer. So I think we can have an independent body like the LSE, maybe not necessarily the LSE, but an independent body administering it, but doing it extremely efficiently, but also having the final say on some of those causes which may not play very well in some of the papers, but nevertheless are absolutely vital in terms of upholding access to justice and fairness in society.
Before I call on the Minister, June and Kat, briefly.
Yes, can I just come back and slightly digressing, but I would like Lord Bark really to clarify this for me, and it was the first question, if I may. Lord Bark, you did say that you wanted the legal aid system to focus on advice as opposed to, of course, representation in court. Now, I do run a pro bono clinic, which I've done for a year, in a GP surgery, and I do offer advice, particularly with regard to social welfare. I don't mean to be flippant about this, because I think that the leaflets produced by the CLS are extremely helpful. And I do frequently refer people to the telephone service, and as I say, I don't mean to be flippant, but when I say to them, ring the telephone service, they will advise you, they say to me, they've advised me to see a solicitor. So I think we have to get that into perspective as well. Advice is fine, but it has a very limited role. We cannot eradicate representation, and forgive me, Lord Bark, this is political. When we see it in the newspapers, and when Caroline Reagan produces letters that go on the internet system, we see that we have so many more people now being able to access advice. They don't need advice, they need representation in many cases, and they are being denied that now. And I fear it is
briefly, in relation to the review announced this week, Carolyn mentioned that these issues need to be kept under review. Well, Young Legal Aid lawyers did a quick tally last night, and since our inception, we've responded to 16 consultations of over 40 in the last 4 years. And now, yet another individual's been appointed, yet again without experience of legal aid, yet again someone who doesn't understand the needs of our vulnerable clients, who yet again is going to be carrying out a review, which is going to be rushed through reporting back in early January this year. I cannot envisage any format within which that review is going to be able to have a meaningful consultation with the profession and the experts in this area. And I really question why we have spent hours of our lives, which we'll never get back, thrashing out the detail of all these tiny proposals, yet again, to have another rehash of the system. It really, frankly, just does piss us off a little bit.
It's not a rehash of the system at all. This is absolutely fundamental. The legal aid system has been absolutely out of kilter. It's been out of balance. And the budget that we have, it spends 1.2 billion on crime. It spends the balance on a variety of civil law. That's completely absurd for a legal aid system. If you're going to change it, then you have to do something about it. I cannot actually believe that Young Legal Aid lawyers are against the idea of setting up a review to see whether the two funds should be split up. That's what the review is there for, among other things. That's the most important thing.
That's not what your terms of reference say.
Well,
That's not what your terms
it is what the terms of reference say, and
It's one of 4 points.
No barracking for the quarters.
it's actually two of the points that are made there, and what we do with the funds, if the funds were split up, how we would administer them. It's an absolutely central question about the centre, about the future of legal aid. So I'm disappointed if you're against the McGee review. I have to say that most people that I've spoken to who want to see progress in terms of legal aid and making it move more towards helping vulnerable people, towards being based on social welfare law, very much applaud the idea that we should be having the review in the first place. As far as the priority consultation is concerned, I have seen already, because I asked to see it, the young lawyers' advice, young legal lawyers' response to it. I think there are many points there that may well be taken up by us. June asked me the question around asylum seeker. I'd be absolutely staggered if there was any scheme that didn't mean that asylum seeker, in the circumstances she was talking about, didn't get legal aid. In fact, our record and the LSE's record of defending the unpopular is very great indeed. And I have to say to Henry, when he starts objecting about the Daily Mail and other right-wing papers complaining about us actually just defending unpopular causes, I don't think I've ever heard a Conservative spokesman say it's absolutely right that the LSE and the MOJ were putting money into this. No, I've seen quick right-wing comments from politicians saying how disgraceful that the legal aid fund is being spent on foreigners or being spent on the wrong sort of person. So I end by just saying this. The future for legal aid, it seems to me, is going to be a very difficult one. There's no question about that. But if it doesn't move towards helping the most vulnerable, supporting law centres, supporting advice centres, in the way that we've done in the course of the last few weeks, we've actually saved South West London Law Centre by stepping in when they were about to go bust. We can't do it for every law centre. We did it for this law centre. That's a test, a real test, of whether we actually mean it when we say we want to see a future for this type of legal aid. What I end by saying is I very much wonder if there was a different other administration with their record on law centres, having not allowed them, all their local authorities closing them down one by one, not giving any money at all to them, whether you really think that a Conservative government would have saved South West London Law Centre, the 5 centres that make up all South West London, My answer is they certainly would not.